Hi, this is attorney Kevin Cran with Cran Law Firm. I want to give you a brief overview of what discovery is. What happens when the judge gives you an initial order saying that you need to come up with a discovery plan, and what is discovery? I'm going to be talking about discovery in the EEOC context and the MSPB context. Discovery is also applicable to all forms of litigation. In short, discovery is the gathering of information by each side. All right? So when you initiate discovery against the agency, there's three common types of written discovery. Number one, that's interrogatories. Interrogatories, just think of those as interrogation questions. That's where we draft questions to the other side so we can get information, and so that we can know who their witnesses are, what exhibits that they intend to produce, who their expert witnesses are. If you don't ask for these things, you may not necessarily be entitled to them, and you could get an unfair surprise at a trial or a future proceeding. However, if you ask for information and you ask for these things, then it's much more difficult for somebody else to try to surprise you later on with something that they could have produced to you in discovery. We also send out requests for production of documents. Document requests. It's just what the name suggests. We're requesting all kinds of documents, and so what we do is we look at the investigative reports, or we look at the underlying evidence, and we try to find out what other evidence is missing, or what documents do we need to try to prove the case, or to try to get more information and clarity. And so we request that information and request for production of documents. The third type of discovery is requests for admissions. This means that you're asking the other side to admit or deny certain facts. If you have a lot of admissions, then you don't need to prove that at court. You can simply show that these things were admitted already. And you can also get a feel for the other side's case as to what items they're denying and what items they're admitting. If they're denying certain items, then you know that this may be an issue. In discovery, you can also do what are called depositions. Okay, so depositions, you may have seen examples like this in the movies. For instance, the movie The Social Network. The inventor or co-inventor of Facebook is subjected to all these depositions, and he's supposedly outsmarting the attorneys in those depositions. But that's a good example of, what a deposition is. It's basically where we get to interrogate under oath witnesses. So we can make them come and provide testimony. You will know what a witness is going to say, and if they stray from the script at a trial, you can call them out on that. You can say, hey, you testified to this at the deposition, now you're testifying to that. So depositions are very powerful. It's also a very good information gathering technique. We don't do depositions in every case because depositions do cost. It costs more for, the attorney time, but it also costs for the court reporter to come, and it also costs to get a copy of the transcript. So we don't do depositions in every case simply because of budgetary reasons. However, they're not necessarily needed in every case for federal employees, because federal employees, unlike any other sector, you get the advantage of an EEO investigation and a report, and you get the advantage of already having sworn statements by management, which is not something you would normally have in normal litigation. Discovery begins with an order from the judge. Usually it's going to be the very first order or the second order that you get from a judge. If it's EEOC, it's going to be in the form of an acknowledgement and order, which will set a date for you to attend a conference with the judge and come up with a discovery plan, in which case the judge will set discovery. Or the judge may just issue an order, just like the MSPB does. They issue an acknowledgement and order, and they say, here's your discovery deadlines. Now, keep in mind that with discovery, you do have deadlines. You have a certain amount of time to start discovery, or you lose your right to engage in it. That's right. So you have to initiate discovery within the deadline set by the judge, which is usually 20 to 30 days. When you send discovery request out, the other side has 20 to 30 days to respond. If it's MSPB, it's 20 days. If it's EEOC, it's usually 30 days to respond to your requests. Another thing to keep in mind is that the agency can also serve you with discovery requests. They want to know all your information and documents and things of that nature. And so we assist you in responding to those requests if they come. Lastly, what do we do if there's a discovery dispute? What if the other side is not getting me the information on time, or they're not getting me all the information I really require? Well, first, you have to pick and choose your battles. If information is not as material to my case, I have to pick and choose my battles, right? But if the agency or the defendant is purposely withholding information that I deem is very material and they have no valid objection, then it becomes necessary to escalate the matter. To enforce discovery, you file what is called a motion to compel discovery. Judges hate discovery disputes. They hate them. That's universally true. Federal judges, state court judges, administrative judges, they all hate getting involved in discovery disputes. And in fact, the regulations and the laws make it a requirement that the attorneys or the parties work out discovery disputes as best they can before they go and bug the judge about it. And so you have to actually, just because somebody's late with discovery, you have to try to work it out. You have to try to call, you have to write the letters. So we immediately start laying that paper trail so that we can comply with the regulations, and so that when it comes time for us to file a motion to compel, we can show that we tried everything and we were forced to file such a motion. And then the agency could be forced to turn over the information, or they could face sanctions if they don't. So that explains the discovery process. So when does the discovery process happen for EEO employees or MSPB employees? Again, it happens when the order first comes. So you've already been through the adverse action. You've already been through, if it's EEO, you've already been through the report of investigation period. So the next thing is you request a hearing, and after you request a hearing, that's when you get the order from the judge, which will set these timelines. So whenever I'm talking to you about the discovery phase coming up, or if you are a federal employee in litigation and you have the discovery period coming up, I hope that this explains some of the key items that you need to keep in consideration. Feel free to give me a call, Kevin Cran with Cran Law Firm.